Thanks, Chairman. Let me join my colleagues in regretting the new precedent that this committee has set in packing two circuit court nominees into the same hearing without the permission or approval of both parties. That, I gather, is a novelty in the Judiciary Committee, and I believe it is a regrettable one. Mr. Ho, the memo that was cited in the Bybee memo does not appear to be publicly available to us. Why is that?
Senator, thank you for the question. That's a memo that I wrote not long after law school when I was an attorney advisor in the Office of Legal Counsel. That's the line attorney position in the office. It was written in my capacity as an attorney for the department. And as such,
why would it not be something that would be disclosed in the context of your hearing and your candidacy for the Fifth Circuit?
Senator, thank you for the question. It's a memo that is subject, as I understand it, subject to attorney-client privilege. It's up to the client in that case.
We've seen the Bybee memo. Isn't that subject to attorney-client privilege by the same standards?
It's my understanding that that memo has been made public.
Right, and yours is not, which is kind of the point of my question.
Right. Well, again, in either context, it's not up to the lawyer involved. I wasn't involved in the Bybee memo. I was obviously involved in the memo I wrote. But in either situation, it's a matter for the client, not the attorney.
I think it's also a matter for the committee. If we are reviewing somebody for a fairly serious position in the Judiciary of the United States, I think it's fair to ask that the documents that they've written before be provided so we have a sense what's going on, particularly when they've been cited in as infamous a memo as the Bybee memo. I mean, it's really hard to have as bad a piece of work come out of the OLC as the Bybee memo, correct?
Senator, it's my understanding that that memo has been disavowed not only by this body,
bingo,
but by the
OLC itself,
by the Justice Department itself,
which is a rarity, correct?
It is indeed, Senator.
Did you, by any chance, do you recall if in writing your memo you came across a decision called United States versus Lee, a decision of the circuit court that you are trying to, that you're a nominee for? And for what it's worth, to prompt your recollection, it is a waterboarding case.
Okay. I'm sort of searching my memory. It's been, I think, when I served at the Office of Legal Counsel, it was it's been a long time.
What would be memorable is that waterboarding was part of the subject of the Bybee memo, and it failed to discuss United States versus Lee, which was a decision that called waterboarding torture, which was, I think, part of what was wrong with that decision. It simply didn't do the research into the cases that were on point. But if you had known about that United States versus Lee case, it would be interesting to see your memo and see if somehow that citation failure was deliberate.
Right. Senator, believe me when I say I appreciate very much the spirit of your question. The reason why it's not, and thank you for clarifying what that case is about, the reason why it's not memorable to me is...
So you don't remember it?
Well, but if I may, I want to explain why. I didn't work, I had no involvement in these issues when I was a lawyer there. So I've never had a chance to study the questions that I understand are very concerning to the committee.
Well,
it's just not been part of my record.
I thought that your memo was entitled Possible Interpretations of Common Article 3 of the 1949 Geneva Convention relative to the treatment of prisoners of war. Wasn't that prepared as part of the work that led to the Bybee memo? That's the topic of the Bybee memo, isn't it?
My understanding of the Bybee memo is that it was about other provisions. Common Article 3, I'm happy to talk about Common Article 3. I'm sorry that the memo is not available, but the Common Article 3...
I don't know if you're sorry. You may be actually really happy that it's not available because we can't see what's in it.
I'm just trying to be polite, Senator.
Yeah, I understand, but there's a little bit more at stake here, and us not getting the documents that we need to evaluate your role in a piece of work that was so embarrassing to the Department of Justice, so tilted, so slanted, such a low point in the history of OLC that it was actually recanted by the department itself. I think that's, kind of a noteworthy thing. And when your document appears as a citation in that memo, and we can't even get our hands on that memo, I mean, Mr. Chairman, there's a point at which this whole process becomes just a joke of ramming people through. It seems to me that this committee not caring to see this document is it's another bad precedent along the lines of stacking nominees together to minimize the amount of question time they have to face without the concurrence of both sides. And I think it just leads us in a very bad direction. I think the Judiciary Committee deserves better than this. I know you get your judges through and you do this, but I just think that from a point of view of the precedent of this committee, this is really getting embarrassing. Thank you, Chairman. Judge Willett, you mentioned a list of points of view that you held, that you advertised in your political race for the court as being the views that you would represent, and or the views that you wish to communicate to the groups that were supporting you. Why would these groups support you as a judge if those views would not ever influence a judicial decision?
Senator Whitehouse, when you're running across 254 counties spread across 2 time zones in Texas.
If you could just focus on the words that I used and the question that I asked, I'd really appreciate it. It was, why would those groups support you for a judicial election if those views were not going to influence any judicial decision you'd ever make?
I can certainly assure you it was not because I gave them any wink or secret handshake or pledge or promise or pre-commitment.
No, it sounds like you gave them a really public handshake and pledge, right? I mean, you put it right out there.
I was happy as a
pro-family, pro-Second Amendment, pro-dark, I don't know what the list was right now. No, there's nothing secret about it. It was a very public pledge.
Well, again, I wasn't describing myself that way. I was describing my supporters. These were people, the leaders of pro-life groups, the leaders of pro-this group,
Wait a minute, your
pro-that
testimony
group.
is that you were not describing yourself?
I would say I was happy to have the support from every corner of the conservative movement, including leaders of this type of cause, that type of cause. I was certainly proud
Why do
to
you
tout their
suppose the
support.
leaders of those types of causes would bother to support you if it would cause no different outcome in judicial decision-making? Is this a form of mass Texan hysteria in which these groups spend money and get involved knowing that there's no effect in judicial outcomes? Explain that.
Senator, I was happy to have their support. There was no assurance, pledge, guarantee, wink, nod, or anything else how I might rule. The North Star for any judge at any level on any court is legal principles, not personal preferences.
I know, you all say that, and it's become rote in these hearings that everybody's going to follow the law. Obviously, when the law is clear, everybody's going to follow the law. The problem comes when, as somebody as distinguished as Justice Cardozo said, when the references in the index fail, when there is no decisive precedent, that's where the serious business of the judge begins. Justice Cardozo is pretty respected, you'd agree.
Absolutely.
How about Justice Frankfurter?
There's a lot to admire about Justice Frankfurter.
So Justice Frankfurter said this assumption that judges only find the law and don't make it is very evil, he said. It's the evil of a lack of candor by covering up the law-making function of judges. We miseducate the people and fail to bring out into the open the real responsibility of judges for what we do. So I feel a little bit lost because we have people here who are spending apparently lots of money to get you onto a court. You're saying that their expenditure of effort on your behalf is totally ineffectual, could have no conceivable result, and therefore presumably is a huge waste of time on their part, but they go ahead and do it anyway. And the reason that it will make no difference is because you will follow the law as if that were the be-all and the end-all of the judging business, when judges as renowned and respected as Cardozo and Frankfurter tell us, which I think most practicing lawyers also know in their gut, that in fact there are decisions where the court is actually making new law. In fact, the common law is judge-made law. So there's something in there that is just not reconcilable to me. It doesn't all add up.
Senator Whitehouse,
Let me ask you one last thing, because my time is running out. At the Office of Legal Policy, you said, and I quote, "We told our nominees to bob and weave, to be the tiniest, teeniest target you can be, and to be as bland, forgettable, and unremarkable as possible." How'd you do today?
Senator, I think we are sadly probably long past the days of Justice O'Connor's 99-0 vote in the Senate, or Justice Scalia's 98-0 vote, or Justice Kennedy's 97-0 vote, or Justice Ginsburg's 96-3 vote. Justice Gorsuch called the confirmation process, he called it an ideological food fight. When Justice White appeared before this committee, he smoked cigarettes and doodled, and Justice Scalia famously smoked his cigar, but things are different today.
My time's expired.